Well, yesterday a federal judge blocked a Florida law restricting how workplaces and schools can discuss race during required trainings. The law, championed by Florida Governor Ron DeSantis and known as the, quote, Stop Woke Act, violates free speech protections under the First Amendment, according to the ruling. Here's Governor DeSantis introducing the law last year.
Florida civics curriculum will incorporate foundational concepts with the best materials, and it will expressly exclude unsanctioned narratives like critical race theory and other unsubstantiated theories. Let me be clear, there's no room in our classrooms for things like critical race theory. Teaching kids to hate their country and to hate each other is not worth 1 red cent of taxpayer money. So we will invest in actual, solid, true curriculum, and we will be a leader in the development and implementation of a world-class civics education.
Joining us now to break down what's next for the Stop Woke Act is breaking news reporter for The Hill, Zach Schonfeld. Welcome to Rising, Zach.
Thanks so much for having me.
So it's pretty clear from the soundbite we just heard from Governor DeSantis what he's sort of directionally targeting. But could you tell us a little bit more about the Stop Woke Act? What it actually, in the substance was doing?
Well, this law focused on a few different things. You saw in the clip there, Governor DeSantis focusing a lot on the education provisions of the law, essentially banning the teaching of critical race theory in Florida. But the lawsuit and the ruling from the federal judge yesterday focused mainly on other provisions in that law, which actually focused on private employers. It included very similar ideas to the education provisions, but essentially what it did is banned private employers in the state from holding any required activities for employees, like employee trainings, from advancing or promoting a series of ideas and concepts related to race, national origin, and sex. So among the concepts that it said private employers could not promote in their trainings and required activities were the idea that individuals are oppressed or privileged because of their race, essentially banning the promotion of the concept of white privilege. It also banned any trainings or activities that allows or enables employees to feel that they must feel guilt or personal responsibility because of their race for past racial injustices. So the federal judge yesterday struck that down, as you said, on a First Amendment challenge, saying it constituted viewpoint discrimination, striking down the provisions related to private employers. But some of the law's other provisions, as you saw in the clip there, related to education and curriculum still stand.
So were there any First Amendment lawyers from the far left to the far right who felt like this could have passed muster? I'm trying to imagine the most sympathetic reading I possibly could on a constitutional basis to the DeSantis law in a way that would allow the state to tell a private company, exactly how it has to write its own training manuals for its own employees. And I'm struggling, other than to kind of slot it into some of the kind of 64 Civil Rights Act provisions. But what was this pure messaging? Was this just a play for headlines? And DeSantis knew, and Republicans knew, that this was going to get overturned? Or was there actually some kind of rationale behind it where they could argue, no, that this is within the First Amendment because of X?
Well, this is one of many bills that Governor DeSantis has pushed through the Florida legislature related to issues surrounding race, critical race theory, and what he is describing as a woke agenda from the left. So this is one of really what has been a bigger initiative and one of the hallmarks of his tenure as governor. The federal judge yesterday struck it down and started his ruling with a pretty, frankly, entertaining analogy, comparing it to the Netflix series Stranger Things. I must admit, I haven't watched the show, maybe I should, but he compared it to the upside down in Stranger Things, this parallel dimension, saying that this, similar to you said, that this law essentially turned the First Amendment upside down, where he said the First Amendment was construed to bar governments like the state from putting burdens on speech while allowing private employers in the private sector to burden speech as freely. He says that this law essentially turned that upside down, where it allowed the state to put burdens on speech, but actually prevented private employers from making those decisions on their own and gave them no choice. So the judge's ruling was a pretty direct strike down of the law. But as I said, it's one of many bills that Governor DeSantis has been pushing through the Florida legislature related to these issues.
And this is actually a fascinating place for constitutional inquiry, because it gets into what constitutes hate speech, what constitutes bigotry, and that's what DeSantis is arguing, is that you cannot promote bigotry by that definition in these public settings or private setting trainings, whatever it is. And so that's where this gets really hairy, and I think also really interesting, because as a society we're hashing out these definitions, we're working off of different definitions. And Zach, what do we know about the next steps? These bills get sort of caught in legislative limbo, in judicial limbo, and nobody even knows what the actual law on the books is. So what's next for the Stop Woke Act's arc in the judicial system?
Well, there's actually a separate lawsuit that happened to be filed yesterday on the same day the ruling came down that more directly challenges those education provisions that Governor DeSantis was communicating in that clip. It challenges those education provisions on pretty similar constitutional grounds, similarly saying it violates the First Amendment's free speech protections. The lawsuit also yesterday in the ruling also struck down the law under the 14th Amendment, under the 14th Amendment's due process clause, saying that the law was impermissibly vague. I think you were getting to that point a little bit, that some of these definitions and the concepts that it was banning, the lawyers in court had argued that they weren't really sure how employers could avoid completely violating the law. So now there's this separate lawsuit going on challenging the education provisions. It's the same two challenges, but in addition, this new lawsuit also brings up a third constitutional challenge, also under the 14th Amendment, but this one is challenging it under the 14th Amendment's Equal Protection Clause. This lawsuit is tying this initiative from Governor DeSantis and Republicans in the state. They say that they had brought this bill forward after all of the outrage following the killing of George Floyd, and that's where this came from. So they say that this law was designed with the intent to discriminate against Black instructors and students, and essentially preventing them from discussing these issues and from professors from promoting certain ideas related to race in universities and classrooms. So that lawsuit was just filed yesterday, and we'll see where it goes soon.
Yeah, and Emily, can you unpack that a little bit more? So is the idea that these companies are the same way that a lunch counter that wouldn't serve Black customers in the 1950s is bigoted and therefore can be regulated under the Civil Rights Act in a constitutional way, that these companies, through their kind of woke trainings, are equally bigoted and therefore also can be regulated? Is that basically the line that DeSantis is trying to draw there to make it constitutional?
Yeah, absolutely. So if the trainings are, for instance, along the lines of some specifics that we've seen come out, where you're teaching white children that by virtue of their skin color, they are automatically an oppressor, that would fall under the definition of bigotry or discrimination. And yes, a lot of people, this is sort of the debate on the right. Is that covered by the 1964 Civil Rights Act, as you mentioned earlier, Ryan? Yes, but is the situation, as some are on the right also argue, so urgent that you need to have legislation that more specifically spells this out and is more specifically tailored to what that looks like in these workplace and school trainings? That's where the debate is, and that's where this law comes in as an example of what that would look like. So I think it is a tough question, because some of those trainings are genuinely like stomach churning, and I think clearly do violate the Civil Rights Act, but it's a really difficult question for legislatures and judges to dive into. And Zach, I think this case study is a great sort of distillation of that broader debate.
Absolutely.
Well, thank you so much, Zach. Oh, go ahead, Ryan. Go ahead.
No, I was just gonna say, if I were gonna try to make the argument for them, I wouldn't flip it to white people and reverse racism. I'd probably try to stick it on, continue with marginalized communities and say that, the way that the trainings are unfolding are saying that if urgency and perfectionism and these other things are products of white supremacy culture, then what it is saying is that people who are not white are therefore, not vested with worship of the written world or a written word or a sense of urgency or perfectionism, and therefore it's racist and subject to some type of regulation. Because I think most liberals would say they would not be okay with education and training that says black people are inferior to white people. So if you can argue that it's in that rubric, that training is in that rubric, even if it's unintentional from the perspective of the trainers, then at least it's not as absurd as it initially sounds.
No, I agree with that completely. I think that's absolutely right. We'll see if they take Ryan's advice. I don't know. Zach, thank you so much for your time and for breaking all of this down for us.
Thanks so much for having me.
Of course. And we will be back with more Rising right after this.